Welcome to Counselor, Beyond Conventional Defense.
Hello and welcome to Counselor, Beyond Conventional Defense, the podcast that challenges the traditional approach to criminal defense and takes a deeper look at how the justice system can evolve, with attorney William Pernik, a trailblazer in criminal defense whose approach is anything but conventional. I am your host, Kevin Rosenquist, and today's episode is Beyond Punishment for Drug Charges, Rethinking Drug Addiction and Mental Health in the Legal System. William, welcome back. Great to see you.
Hi, Kevin. Thank you for having me.
All right, so we talked a lot last week about our last episode about how your approach is not conventional. Can you kind of walk us through the steps you take when you first meet with a client who's facing drug charges?
Absolutely. I think that when we talk about the approach that me and my team is utilizing, I think the correct way to describe it would be that we have additional tools that we bring to defending our clients. Our approach utilizes existing knowledge in order to still challenge cases where people's constitutional rights were violated, where police officers perhaps illegally detained, arrested, searched, or questioned an individual. If there are facts that obviously show our client is innocent, we can still present it. But the conventional approach has limitations. The conventional approach is confined to applying rules of criminal procedure to potentially attack evidence that was obtained unlawfully, or statements that were obtained in violations of someone's, for example, Fifth Amendment privilege against self-incrimination if police didn't read them their rights when they were in custody and being interrogated, or limited by the facts of the case, because we cannot change facts. We can try and uncover additional facts. We can advocate for different interpretation of the facts that we have, but lawyers cannot change facts of their cases. If someone was found in possession of an ounce of methamphetamine on their person, in their backpack that was on a passenger seat in a car, and they're the only person who was in the car at the time, and the backpack had their wallet and all kinds of personal information, I cannot change that fact. I can argue in court what that actually means. I can argue whether these drugs were possessed for purposes of sale, for purposes of personal use, maybe somebody else had custody of the backpack, but I cannot change basic operational facts that we have. The beyond conventional defense approach does not focus so much on the law or the facts. It blends psychology and the law by getting at underlying reasons for person's behavior. So we would not be arguing over whether your drugs or somebody else's drugs, whether they're in a backpack or not. We would have a conversation about, okay, you're obviously in a possession of a large quantity of narcotics. You've had a history of other cases. I can look at your criminal record and I can see that you've had multiple convictions for possession of drugs, for being under influence of drugs. So it tells me that you are not just a person that police claim is selling this to other people, that you yourself use. You've had some history of using. Tell me more about how that happened. Tell me about how that came about. And so the first step that I take is I have a conversation with my client, and I try to understand not only what they did, that's a given, but why they may have done it. And if what they're accused of is not what they did, then we need to understand, why does it look like you may have done it when in fact you have done something else or have not done anything at all. So it's the power of asking the question why that provides us with additional information that we can use in order to build a much better, stronger defense for a person and pursue far greater legal outcomes.
Using this unconventional approach, this psychology-based approach, are there any specific challenges that you find that this approach brings up when defending someone against drug charges?
I think the biggest problem we have is that we're going against established way of thinking.
Right.
In a conventional drug sales case, that's a case that involves somebody possessing drugs for sale, somebody transporting drugs for the purpose of sale, somebody smuggling drugs into a controlled environment, like a correctional institution, for example, a county jail, a state prison, or juvenile hall, or somebody selling it perhaps to an undercover officer or advertising it online. Okay. In a conventional approach, we are limited to certain things, and there are expectations that certain things will be discussed in court. I can tell you exactly what they are because police officers are trained on them, so are the prosecutors, and so are the defense lawyers. So anytime when we find a person in possession of a quantity of drugs, here are the questions that everyone's going to ask. Number one, how much drugs did police find this person to possess? The more drugs they possess, the more likely they're to be a dealer. The smaller the quantity, the more likely they are to be a user. That's conventional wisdom, okay? Step two, how were those drugs packaged? Do they appear to be packaged for sale? Do they appear to be a singular item that a person can take and use? Number three, did the person have anything else in their immediate environment that suggests they were selling drugs? For example, do they have a scale? If they have a scale, the government's going to claim they were weighing out the product. We're going to argue that, they are a user, they're rationing their consumption because they're struggling with an addiction. That's why they have a scale. Did they have packaging material, lots of baggies, plastic wraps, things like that? Why would somebody need to have 5,000 baggies if they're a user? So presence or absence of packaging material is what lawyers discuss and argue over in a conventional approach. The presence of text messages that suggest some sort of sales-related activity. If somebody is texting my client asking them how much is an ounce of meth, government is going to argue that this is a customer asking how much my client is willing to sell it for. I'm going to potentially argue, if I'm using conventional approach, that people know he's an addict. He knows people who are good connections for buying drugs, so they're asking, hey, how much could I buy one if I wanted to, in this quantity, right? The presence of any kind of business records, which in the industry we call payo sheets, basically transaction ledgers, but very crudely, it could just be a list of names and amounts. Police officers, if they find it, they're going to be super happy. They're going to say, these are business records that demonstrate this individual is selling drugs. And then, of course, if the client confesses to possessing drugs for sale or selling drugs or actually sold it to an undercover, that's going to be used very heavily. And so in a conventional approach, number one, we're going to see if there is any legal reason to get rid of all of this evidence. Is there some violation of our client's right? Was this a bad search? Was this a bad arrest? Was this warrant obtained on bad information or misinformation? Was the snitch lying? Things like that. So one approach is using the law and specifically rules of criminal procedure to get rid of this evidence. And if it works, great, your client walks, case is over. You still haven't fixed the problem that brought them to you in the first place. You're going to have a repeat customer because they're going to tell everybody else who sells drugs, this lawyer is really good. He got me off so I can go back to selling drugs. You're going to have pissed off cops that will follow him and try to do a better job catching him next time. And you'll make another, customer out of him and everybody else who he refers to you. That's how you use the law to challenge it. Factually, you would use these 7 factors that I just mentioned. Cops, by the way, call them indicia or indicators of sale. So these 7 factors are present in every single sales case. I've recorded a video on that topic actually on our YouTube channel. But in a conventional approach, we can argue the meaning of those facts. Does my client's possession of an ounce of meth mean that he's a drug dealer, or is he somebody who's a functioning addict who bought it in bulk because it's cheaper and avoids multiple interactions with dealers, right? Does my client's possession of a scale indicate he's likely a merchant as opposed to a user? Things like that. But at some point, you're going to run out of room to argue. And at some point, you're going to find yourself where you either have an offer your client needs to accept or reject, or you go to trial with all of the risks that it entails for a person, especially a person who may not be a citizen, a person who has a prior criminal record. And that's where the beyond conventional approach comes in, because here we can get to the underlying problem. We don't have to argue or fight the facts. We can use this approach after we've exhausted the legal challenges to whatever evidence was found in the case, if we choose to do that. And everyone can understand, if you present correctly, mental illness, substance abuse. Not everyone can understand the decision to just sell drugs. And so once you identify correctly what the problem is that led to your client possessing the drugs that the client possessed, once you craft the solution and you present it persuasively, you can get your client into a program like a mental health diversion program. Once you understand the underlying problem that led your client to being arrested for possession, for sale or transportation of drugs, if you understand that this is a person, for example, who is an immigrant to this country, who suffered abuse or trauma, who lost their job, who had a family to support, who was using drugs to cope with the stress and who made the decision that the easiest way to get money to support my habit is to also sell some of the drugs I buy for myself to other people I know, maybe my friends, maybe my associates, maybe people I know through my community or my neighborhood. This way I can make some money on the sale and have enough money to also support my habit. Most of my clients are not high level importers or distributors of drugs. I have
Yeah,
those
not
cases on
kingpins.
occasion. It happens from time to time, but just the statistics are such, the majority of people you will represent as a criminal defense attorney will be people who both use and sell drugs. So where do we want to channel these cases? Drug dealers go to jail. Drug users should go to get treatment. And if we want treatment to be successful, just like we saw in prior episodes, using one of my clients as an example, Adina, if you really want drug treatment to work, you want to make sure you rule out anything other than just addiction. Because if there are other problems that cause the person to become addicted to drugs, you need to address those, or your treatment is not going to be successful, or it's going to be short lived. Because you might fix the problem that led them to you today, but if you don't address the underlying cause for that problem, it's only a matter of time before it's going to come back.
You're passionate about this. You can sense it in you just by the way you talk. What do you believe the legal system could do better to address the root causes of drug addiction and mental health struggles instead of just focusing on punishment?
I think the legal system needs to properly allocate resources to match the need for treatment with the resources that it makes available. In some ways, it's basic principles of supply and demand. The demand for these treatment-based solutions is extraordinary. 50 to 75% of all people in criminal justice system will have some sort of mental health or substance abuse issues. But if you look at the breakdown of distribution of business in any courthouse, in any county, in the state of California, you will see that, yes, they do offer treatment programs, but the percentage of programs that they actually offer is so statistically smaller than the total number of people that we know need these problems, that we're trying to, we have a boat that's sinking because it's taking in or taking on so much water, and we're using a cup to bail the water out. It's not going to work. We need to make more resources available, and we need to educate people. And I think there's a really big problem in not training a generation of future lawyers, future public defenders, future district attorneys, and subsequently future judges on what it looks like when a person is going through a mental health crisis, what it looks like when a person is badly addicted. We're not teaching people correctly in law schools that if you are a law student, if you're a second year or third year law student passionate about criminal law, like I was, if you want to do criminal defense or if you want to prosecute, you need to understand who you're going to be working with. And we're not telling people the truth about who they're going to meet once they get that job. We're not saying, Kevin, when we hire you as a prosecutor in this office, you're going to spend 50 to 75% of your time incarcerating mentally ill people and drug addicts. How do you feel about that? You want to do that?
No.
We're not saying, you see what I'm saying?
Yeah.
We're telling you that you're going to be, you're going to be like Batman. You're going to be saving neighborhoods from crime. We're not telling you the truth, the grim reality of what you will experience day in and day out until after many years of this, you'll make it on some sort of major crimes team or special prosecutions team where your assignment is going to be more limited, and you'll see perhaps more of the people that belong in the other 25%, right? The ones that just commit crimes because of some underlying criminogenic factors as opposed to underlying mental health or substance abuse issues. We're not telling future public defenders, hey, William, when you get hired in this office, just so you know, 75% of your time you're going to have to be dealing with finding people programs and treatment and things like that. How do you feel about that? I would have loved it if somebody told me that, 20 years ago. But a lot of people I know, many of people that were my friends and my colleagues would say, hey, man, I didn't go to law school to be a social worker. If I wanted to be a social worker, I would have gotten a master's degree. I wouldn't have borrowed, $250,000 to get a law degree, and I wouldn't have had to study for the bar exam. And we need to stop and say, well, actually, that's the job. This is who you're going to be dealing with. And until we do that, until we're all honest with people, until we properly allocate resources where they are needed, we're going to have a revolving door. And we will go from one extreme to another in California, either over criminalizing or decriminalizing certain offenses. And we will waffle between one extreme or the other until we actually get smart, get serious, use data, use science, and actually start fixing people.
That's a good segue, because I wanted to kind of wrap up this episode with a different approach to that. What about policy? Because we're talking about how we can change things in the judicial system, but from a government policy standpoint, do you think that this needs to be rethought as far as how they look at drug policy in California?
When you say they, who specifically do you mean? Do you
Just
mean law
the state.
enforcement?
Yeah,
You mean
no, I'm talking more about
legislator?
the lawmakers in California.
I think they've done that. I
Okay.
think I think they've done that to some extent because we have some incredible statutes that have actually been passed. It's a different story how they got passed. They didn't get passed, for example, after an open and honest debate and commissioning studies and using science and knowledge to really persuade everyone, including people you don't agree with, that this is the right way. We have a mental health diversion statute that was passed, I believe, as part of like budget, reconciliation maneuver. So this mental health diversion statute that California legislature finally passed, however they did it, it gives a person a powerful incentive to not have a criminal conviction at the end of the case if they're willing to walk the walk, if they're willing to stick it out for a year on a misdemeanor case or 2 years on a felony case. And many criminal cases, misdemeanors, for example, a domestic violence misdemeanor carries 3-year probation. Now you can complete mental health diversion in 1/3 of the time. Felony probation on many cases, again, domestic violence case would be 3-year. Child abuse, child endangerment, 4 years. You can complete it in 2 years. It's going to be intense treatment. It's going to be court supervised, but you have input in your own treatment plan. You can use private resources, or if you're indigent, you can use county-based solutions, and you can actually get to the root of the problem. You can use a scientifically based solution, and you can change a person's life. And the recidivism rates, Kevin, are virtually non-existent. I got to tell you, I've been doing this for almost 20 years. I have represented thousands of people who were placed on conventional misdemeanor or felony probations. They violate them all the time. In Los Angeles County, they have a barcode that you scan to check in with your probation officer. Okay, it's not even a meaningful reporting probation for most people unless you are the most serious of the probation cases. There's very little supervision in some of these large places. And yet, this type of approach allows for intense supervision by the court, input from everyone involved, and using science and understanding and knowledge to actually help the person move past the worst decision in their life and achieve a better legal outcome and a better future. And at the end of the day, it not only benefits the person, it benefits society, and it positively impacts everybody else along that person's journey because it is motivating, it is inspiring, and it is a net positive as opposed to a negative. You don't have that feeling that I used to have coming back after a long day of public defendering where I felt that I just spent 10 to 12 hours of my life today standing at the revolving door. I feel like I've actually accomplished something and helped a person. And I didn't have to go through 57 different cases to help this one individual. I can help so many more of them.
Yeah, that's really cool. All right, well, thanks for tuning in to Counselor Beyond Conventional Defense with attorney William Pernik. To connect with William and his team, head to perniklaw.com, and please like and subscribe to our channel. We love having you here. William, I loved talking to you. Thanks so much for all the insights. Always a pleasure.
Thank you, Kevin. I look forward to continuing our discussions. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.